morning. The topic assigned to me for today is on the pitfalls of enforcing and rejecting a foreign arbitral award in the Philippines. So for in-house counsels, I'm sure that most of your contracts involving multinational companies would involve an arbitration clause. And as often the case, it's either you win or you lose in an arbitration. So the question now for this talk is what to do with a foreign arbitral award. So first, let's view the landscape. Let's check the applicable rules and laws pertaining to foreign arbitral awards. And we begin with our PowerPoint presentation. Now, the basic or the fundamental law governing arbitration or arbitral awards would be Republic Act 9285 or the ADR Law. And this law was enacted sometime in 2004, which formulated the rules and regulations governing the implementation of arbitration rules, procedures, and enforcement or recognition of arbitral awards. Now, the law prescribes certain procedures. It has its implementing rules and regulations, but the Supreme Court also promulgated the special ADR rules. We refer to them simply as the special ADR rules, promulgated in 2009 or 5 years after the law was enacted. So when we discuss foreign arbitral awards, we will be basically talking about the ADR Law, Republic Act 9285, the special ADR rules promulgated by the Supreme Court, and of course, the basis for all of this, the New York Convention on the Enforcement of Foreign Judgment. So let's begin with the fundamentals. I think first we need to clarify certain terms which are often confusing to some lawyers or interchangeably being used by most lawyers. But they actually mean different things. So how do we distinguish the following terms? First, international commercial arbitral award. Second, a foreign judgment. And then how do we distinguish these two from a foreign arbitral award? We now move on to the second term that is often confusing. So first we discuss international commercial arbitral award. Now we talk about a foreign judgment. No? So an international commercial award refers to one that was held in the Philippines. No? So the arbitration was held in the Philippines. For a foreign judgment, we refer to decisions of courts, no, in cases held outside of the Philippines, hence foreign judgment, and it's governed by Section 48 of Rule 39 of the 1997 Rules of Civil Procedure, and foreign judgments are only considered presumptive evidence of a right as between the parties, and it may be repelled by evidence of lack of jurisdiction of the issuing authority or want of notice, lack of notice to the party against whom it is enforced, or collusion, fraud, or clear mistake of law or fact. So these are the grounds by which you can repel or reject a foreign judgment. So again, to distinguish it from international commercial arbitral award, a foreign judgment is held outside of the Philippines. So it's usually a decision of a court outside of the Philippines. Now, the third word or term is a foreign arbitral award, and that is the topic of today's talk. So, foreign arbitral award. When we say foreign arbitral award, it is rendered by an arbitrator or a panel of arbitrators in a foreign country, as distinguished from an international commercial arbitral award, which is rendered by an arbitrator or arbitral panel in the Philippines. Now, the grounds for recognition, enforcement, or rejection or setting aside is found in Rule 13 of the Special ADR Rules. Now, are foreign arbitral awards immediately executory? So, assuming that you are the prevailing party in an arbitration, say in Singapore, from the Singapore International Arbitration Center, and you now have an arbitral award, a foreign arbitral award, can you now go to the Philippines and immediately implement or execute this award? Well, the answer is no. Under Section 35 of the Uncitral Model Law, which is adopted by the Philippines as a template or a basis for our ADR law and special ADR rules, foreign arbitral awards are not immediately enforceable and they cannot be implemented immediately. And this was the holding of the Supreme Court in the case of Korea Technologies versus Lerma, a 2008 case. Now, in this case, the Supreme Court said that a foreign arbitral award is subject to judicial review by the regional trial court, which can set aside, reject, or vacate it. And these arbitral awards are not absolute and without exceptions, as they are still judicially reviewable. So you might notice that there is an underlined portion. It says that the RTC, the trial court, can set aside, reject, or vacate it. This was decided prior to the special ADR rules. The special ADR rules were promulgated by the Supreme Court sometime in 2009. So this was decided in 2008. In 2009, under the special ADR rules, the trial court can no longer set aside or vacate. That can only be done by a competent court in the place, the country, where that foreign arbitral award was issued. Under the special ADR rules, the trial court can only choose to implement, to recognize, or to refuse recognition. Now, so when we refer to Article 35 of the Uncitral Model Law, it says that an arbitral award, irrespective of the country in which it was made, shall be recognized as binding upon application in writing to the competent court, shall be enforced subject to the provisions of this law. So under the Uncitral Model Law, which is the basis of our special ADR law, you need to file an application in writing or, under our rules, a petition to have the foreign arbitral award enforced or recognized in the Philippines. So the rule of thumb is that you cannot rely or implement a foreign arbitral award unless it has been recognized or enforced by a competent court in the Philippines, pursuant to the rules. And under Section 42 of the New York Convention, which was adopted also by RA 9285, it says that the recognition and enforcement of foreign arbitral award shall be filed with the RTC in accordance with the rules promulgated by the Supreme Court, which we refer to as the special ADR rules. So what is the rule if the foreign arbitral award came from a non-convention state? So meaning, what if the foreign arbitral award was issued by an arbitration tribunal or an arbitrator in a country who is not a signatory to the New York Convention? How should Philippine courts treat these foreign arbitral awards? And under Rule 13.12 of the special ADR rules, it says that if the foreign arbitral award is rendered by a country that does not extend comity and reciprocity to awards rendered in the Philippines, the trial court may treat such award as a foreign judgment, meaning it will only be considered as a prima facie evidence of a right. So the governing rule would be Rule 39, Section 38. Section 48 of Rule 39 of the Rules of Court on the enforcement of foreign judgment. So, we need to emphasize that a foreign arbitral award is different and cannot be deemed to be a foreign judgment. Those are two different things. So, foreign arbitral award, when confirmed by a court of a foreign country, shall be recognized and enforced as a foreign arbitral award and not as a judgment of a foreign court. Because the difference is stark. There's a great difference between the two. A foreign judgment is only prima facie evidence, while a foreign arbitral award is binding and executory once it is recognized by a competent court in the Philippines. Now, so how do we enforce a foreign arbitral award? So you're the in-house counsel of a company and you secured a favorable award from a foreign arbitral tribunal, possibly in Hong Kong or in Singapore. So what do you do with that? How do you enforce that in the Philippines? Under Rule 13.1 of the Special ADR Rules, it says any party to a foreign recognition may petition the court to recognize and enforce a foreign arbitral award. So there is a positive act that is required of the prevailing party, and that is you need to file a petition to have it enforced or recognized in the Philippines. And the contents of such petition are enumerated in Rule 13.5. So, first, you need to state in the petition the addresses of the parties to the arbitration. And these are the pitfalls. No? So, who do you sue in that petition? Of course, you will name as defendant the losing party, the one against whom the foreign arbitral award is being invoked. Now, in the absence of any indication in the award, the country where the arbitral award was made must also be stated in the petition, and whether that country is a signatory or not to the New York Convention. And why is that relevant? Because if that country is not a signatory to the New York Convention, the foreign arbitral award will be treated as a foreign judgment. No? And then C, the relief sought. So what is it that you're asking from the court? Are you asking for enforcement, or are you asking that the foreign arbitral award be rejected or refused recognition? Next, you need to attach a copy of the arbitration agreement or an authentic and an authentic copy of the arbitral award. Sometimes there are confidential matters alleged in the award. You can ask the court to keep the matter confidential, because under most arbitral institutions, there is an institutionalized policy for confidentiality, but the courts may not follow that. So you need to file a motion to ask the court to treat these records as confidential. If it's in a foreign language, you need to submit translation in the English language from a diplomatic or consular agent or an authorized translation. Now, this is a curious question. Can the losing party preempt the enforcement or recognition and file a petition to reject or refuse enforcement even prior to any moves from the prevailing party to have the foreign arbitral award enforced or recognized in the Philippines? Can you preempt the prevailing party? Can you file this petition to refuse or reject enforcement even if the prevailing party has not even taken any moves to implement or recognize the foreign arbitral award? Is that allowed under the rules? Well, the answer is yes. Rule 13.4 of the Special ADR Rules expressly provides that a party may make an application to refuse recognition and enforcement of the award. So this is clear that the rules says that you can apply to have this refused recognition, or that the court should reject this foreign arbitral award. By the use of the phrase application, it means initiatory. It didn't say that you can only do this in defense of a petition to enforce. So the language of the rules clearly allow a petition, an initiatory pleading, a petition to refuse recognition or to reject a foreign arbitral award even prior to the filing of any action to enforce or recognize the foreign arbitral award. Also, under Section 42 of the ADR Law, it expressly allows an application for rejection or suspension of enforcement of an award to be made. So you have two legal bases that justifies a losing party to preempt the prevailing party by filing a petition to refuse recognition or a petition to reject the enforcement of a foreign judgment. Section 42 of the ADR Law and the Section 13.4 of the Special ADR Rules. Now, assuming that you will file a petition to enforce, or in the alternative, you're the losing party and you would want to preempt it, you would want to file a petition to refuse recognition or to reject the enforcement. where will you file it? Now, under the rules, the one filing has the option. You can file it where the arbitration proceedings are conducted, or two, where the assets to be attached or levied upon or the act to be enjoined is located. Third, where any of the parties to the dispute resides or has his place of business. Or fourth, anywhere in the national capital region. So you have four options on venue where you intend to file the petition for enforcement or petition to refuse recognition. So how much are the filing fees? So is it dependent on the value of the award? Actually, the answer is no. Since Philippine courts, in the case of Mijares versus Judge Ranyada, the Supreme Court said that this kind of action, an action to enforce a foreign judgment, is incapable of pecuniary estimation. Therefore, there is only a standard fee, filing fees for such an action. It's not dependent on the value of the award. So how much are the filing fees? Minimal, said the special ADR rules. Now, Rule 20.2. The minimal filing fee payable in all other actions not involving property shall be paid by the petitioner seeking to enforce the foreign arbitral award. Now, can a foreign corporation not licensed to do business in the Philippines file a petition to enforce a foreign arbitral award? So the prevailing party does not do business in the Philippines, but the losing party, the one against whom the foreign arbitral award will be invoked, is in the Philippines. So this prevailing party who does not do business in the Philippines, therefore doesn't have any license to do business in the Philippines, will be coming here to sue only on this instance. Can he do that? The answer is yes. The foreign corporation's capacity to sue in the Philippines is not material insofar as the recognition and enforcement of a foreign arbitral award is concerned. Because under the rules and under the law, you can only reject a foreign arbitral award based on the grounds recognized by Article 5 of the New York Convention or Section 45 of Republic Act 9285 or the ADR Law. And lack of capacity to sue is not one of those grounds. So this was the ruling of the Supreme Court in the case of Tuna Processing Inc. versus Philippine King Ford Inc., a 2012 case. Now, so how would the parties be notified if an action to enforce or reject a foreign arbitral award is filed? Now, under Rule 13.6 of the Special ADR Rules, they will be notified by personal service or by courier. And if they cannot be served by personal service or courier, then registered mail will do. How about summons? Well, the technical rules of summons do not apply. And this is specifically mentioned in the special ADR rules. Therefore, you don't have to look for the president or secretary or treasurer or any officer. You don't need to go there personally. In fact, you can serve by email or publication. So, under the rules, what is essential is that the service of the copy of the petition and notice of initial hearing was made in such a manner as to reasonably ensure receipt thereof by the respondent to satisfy the requirement of due process. One of the pitfalls of serving summons to a foreign corporation not doing business in the Philippines is that it doesn't have any business in the Philippines. Or when the corporation has already been disbanded or the corporation already moved out of its office, possibly trying to evade or avoid having to pay the arbitral award, you don't know where they are. So in one case where we are the lawyers of the prevailing party, we had to resort to service by publication. And that is allowed under the rules because the technical rules of summons do not apply. It can also be served on the resident agent in the Philippines. It can also be served by email because the rules, the technical rules of summons do not apply. And so what is the period to file answer? Under the rules 13.6 and 13.7 of the special ADR rules, the respondent is required to file a verified opposition within 30 days from receipt of the notice and the petition. So it's 30 days. And take note that this period is not extendable because under the rules, a motion for extension to file any pleading or motion to reset is a prohibited pleading under Rule 1.6. If the respondent doesn't answer, can he be declared in default and after the 30-day period? Well, the answer is no. Under the special ADR rules, respondent's failure to submit an opposition or answer shall not be a cause for a declaration of default, no? Because a motion to declare defendant in default is also a prohibited pleading under Rule 1.6G. So once the respondent has filed its opposition or the period to file opposition lapses, the court will determine whether the issue between the parties is one of law or a question of fact. So this is very, very important. So what will happen if the court determines that the issue between the parties is only a question of law? Under Rule 13.8 of the special ADR rules, if the issue is mainly one of law, the court will require the submission of a brief of legal arguments, not more than 30 days from receipt of the order. And one unique feature of this legal brief or memorandum is that the lawyer submitting it must verify it. Unlike the usual rules that it is the plaintiff or the defendant who executes the verification, here the rule says it is the lawyer who should verify it. Why? Because more often than not, in the enforcement of foreign arbitral awards, the plaintiff or the defendant are foreign corporations and they're not here, only their lawyers. So the rule says the lawyers can verify it. If the issue or issues between the parties are issues of fact, then you need presentation of evidence. And under the rules, the court can require the parties to simultaneously submit the affidavits of their respective witnesses within a period of not less than 15 nor more than 30 days from receipt of the order. Will there be a need to call these witnesses so that they can be cross-examined, for example? Under Rule 13.9 of the special ADR rules, if the court determines that a hearing is called for, the affidavits of the witnesses take the place of their direct testimonies. So they can be called to attest and affirm their judicial affidavits and they can be cross-examined immediately. For foreign witnesses, they don't have to go to the Philippines. They can avail of a deposition upon oral examination in a foreign country. Or as we now adopt the virtual court hearings, you can also be deposed virtually, online through many platforms that they use. Now, can the RTC refuse to enforce? The answer is yes. After the proceedings and the RTC or the trial court is convinced that there are grounds to reject or refuse enforcement, the RTC is empowered to refuse. Under Chapter 7 of RA 9285, all arbitral awards, whether domestic or foreign, are subject to judicial review on specific grounds provided for. So while a foreign arbitral award is binding, it is still judicially reviewable and the RTC can refuse to enforce or to even reject a foreign arbitral award. Can the RTC vacate? When you say vacate, to change the judgment, change the terms of the judgment. Well, in one case, the Supreme Court said that the RTC can refuse to vacate, refuse to recognize, to set aside, or even to vacate. That is the case of Korean Technologies versus Lerma. But as I said, that was decided by the Supreme Court in 2008. In 2009, the special ADR rules now provide under Rule 19.11 that the court can only deny recognition and enforcement of a foreign arbitral award, but it has no power to vacate or set aside a foreign arbitral award. So if a petition to set aside a foreign arbitral award is filed, the RTC should consider it as a petition to refuse recognition, or a petition to reject enforcement. Because the court cannot vacate, cannot change the terms of the award, cannot substitute its judgment for that of the arbitral tribunal or arbitrator. Can the RTC annul a foreign arbitral award? Can it declare the foreign arbitral award as invalid or null and void? The answer is no. The RTC is not tasked to determine whether the foreign arbitral award is valid or not. Take note that the foreign arbitral award remains valid. It has already been litigated in a foreign country by an arbitral tribunal or an arbitrator with set rules which the parties agree to. So this award is already binding between the parties. The only issue is the enforcement. So even if the trial court denies or refuses recognition and enforcement, the award remains to be valid and binding between the parties, because the primary authority to declare that the foreign arbitral award is invalid is vested in the court of the state in which the arbitral award is rendered. And that is an action to vacate or to set aside a foreign arbitral award in the country where that award was issued. So in the Philippines, we have the following grounds for judicial review of an arbitral award, or these are the grounds by which a trial court can refuse recognition or reject the enforcement of a foreign arbitral award. Number one, when the subject matter of the dispute is not capable of settlement or is not subject to arbitration under Philippine laws, or when there is a public policy exception, when the recognition or enforcement of the award will be contrary to a known public policy in the Philippines. So what disputes are not subject to arbitration? So under Section 6 of Republic Act 9285, disputes that cannot be the subject of arbitration are as follows: labor disputes, civil status of persons, the validity of marriage, any grounds for legal separation, the jurisdiction of courts, future legitimate criminal liability, and those which by law cannot be compromised. Yan. In relation to a trial court's authority to refuse recognition or reject enforcement, we also have Article 36 of the Uncitral Model Law, grounds for refusing recognition or enforcement. And one of the grounds would be if a party to the arbitration agreement was under some incapacity, or the said agreement is not valid under the law to which the parties have subjected it, no? Or the party against whom the award is invoked was not given proper notice, or the foreign arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration. You can also invoke the composition of the arbitral tribunal, that the arbitral procedure was not in accordance with the agreement of the parties, or that the award has not yet become binding on the parties, or it has been set aside or suspended by a court of the country in which the foreign arbitral award was made. So assuming that the trial court issues an order and that is an adverse decision, where do you go? What do you do? The first remedy would be to file a motion for reconsideration within 15 days. And again, this period is non-extendable because a motion for extension is a prohibited pleading, and the period to file the MR or motion for reconsideration commences to run from the time that you receive a copy of the decision. Now, if the RTC denies the MR, then you can bring it up to the Court of Appeals. So this is by way of a petition for review. No? You have 15 days from notice of the decision or the denial of the motion for reconsideration. The prevailing party who is enforcing the foreign arbitral award can immediately apply for execution of the award, because the losing party, the one appealing the decision of the RTC, is required to post a bond pending appeal. No? And under Rule 19.22 of the Special ADR Rules, even if the losing party files an appeal, the appeal shall not stay, it shall not prevent the execution or implementation of the foreign arbitral award or order. Is certiorari available for an interlocutory order? Well, Rule 19.26 of the Special ADR Rules allows a certiorari petition for only one instance, and that is to assail the RTC's decision allowing a party to enforce a foreign arbitral award pending appeal. All other matters not covered by certiorari. And the petition for certiorari should be filed within 15 days from notice of the RTC's decision or order that you seek to review. So assuming that you went to the CA and the CA denied your petition or issued an adverse decision, what is the remedy? Well, you may go to the Supreme Court by way of a verified petition for review, again within 15 days from notice of the decision or denial of the MR, and this is also non-extendable. And what are the grounds for the Supreme Court to review a petition? So it's very, very limited grounds under Rule 19.36, and you must invoke them in your petition when the CA or the RTC failed to apply the applicable standard or test for judicial review, when the court erred or committed an error in upholding a final order or decision despite lack of jurisdiction, or when the court failed to apply any provision, principle, policy, or rule contained in the special ADR rules, or when the court committed an error so egregious and harmful to a party as to amount to an undeniable excess of jurisdiction. So that ends our discussion, and we thank you for listening, and we are now available to answer your questions.